Kada je dovoljno ugrijao te pisete, počeo je da me prži. Naredio me da zinem, ja sam zinuo, da ispazim jezik. Ispazio sam jezik, on je počeo da prži, doživljavao sam strahovite bolove.
Torture is the infliction of severe pain and suffering on an individual because of who they are, what they believe, or for some other kind of purpose. And it's used to humiliate.
I da moramo naglas reći: ja ljubim ovu srpsku zemlju. Ja sam srpsko kopilje. Ovo je srpska zemlja.
And it's usually something which is done by a person in authority.
To je bilo za mene najveće poniženje. Ja bih volio metak nego da to kažem. Ali nisam mogao metak dobiti jer su batine, teške batine.
I actually don't see how your psyche can ever escape harm or hurt from being tortured.
There are no exceptions to the prohibition against torture.
Torture goes back a long way. I mean, ever since man walks the earth and decided to have a judicial system, torture was involved. Now, for example, we are here standing in a jail, in the 16th century jail. It used to be part of the court of Holland, which was the main court, the highest level of court in the province of Holland, back in the 17th, 16th century. And here torture was used being part of the process. So it wasn't as much a part of punishment, it was a part of truth finding.
Well, the use of DNA evidence or fancy techniques to find out what happened is relatively new historically. From that sense, questioning an individual who's suspected of a crime is a classical way to find out whether or not a crime took place. The use of torture has been, well, it's a practice that's been used to put pressure on an individual who refuses to talk and to encourage that person to agree that they are the ones that are responsible for a particular offense.
How would they make them talk? There were many ways. I mean, for example, one of the more used ways in Western Europe, at least, that we know from images, from prints, is that they would tie someone down on a bench. We used to be tied down with ropes very tightly. Then the ropes would be made wet. They would dry out, so that you would even get tied more. You would suffer actually from being almost suffocating. And then they would start pouring water in you through your mouth, and then to fill your belly, and then start hitting your belly.
Over quite a long period of time, it became progressively recognized that it was important for the rule of law to exist, and that people had a right to a legal system which was fair, which was just, and which sought at its heart to get at the truth. So you had a movement from a state where brute power and force was used to get the compliance of the population to a social contract model.
Torture was stopped actually late 18th century, for sure. I mean, mid-18th. But in every country it's different. But you see this civilization process, we could say, towards getting a judicial system without torture. Because we believe that humans, I mean, at the end of the 18th century, you get these international rights of the man. I mean, the French Revolution, and also here in the Netherlands, many of those ideas of the Enlightenment were taken over and became part of our judicial system. And one of the main things was, of course, the integrity of the human body, in a way. So it's a process that started, I would say, a little more than 200 years ago.
It's quite interesting because the classical way in which torture is understood is an individual who is accused of a criminal offense. They're in a detention cell and the interrogators are questioning them, seeking to elicit a confession. But it's been proven time and time again that forcing someone to confess is not the best way to get at the truth. In fact, quite the opposite. People will say anything just to stop the pain and the suffering.
Korištenje mučenja kao sredstva za isljeđivanje ukinuto je u zapadnim pravosudnim sistemima tokom 18. i početkom 19. vijeka. Od tada se i nacionalno i međunarodno pravo postepeno razvijelo u pravcu zabrane zlostavljanja zatvorenika.
International criminal law is, to a large extent, have been fed by international humanitarian law on the one hand and international human rights law on the other. The first development of these rules on how to treat detainees, whether civilian or combatants, were developed in international humanitarian law.
Two main branches of law have developed in a sense in parallel. One, the human rights treaties, the human rights framework, which had its greatest impetus after World War II, and international humanitarian law on the other side, which has a longer trajectory and perhaps was more detailed at an earlier stage. But each has influenced the other, and from a humanitarian law perspective, the law was rather vague for quite some time.
Nakon prvobitnih pokušaja da se u Haškim konvencijama osigura čovječno postupanje sa zatvorenicima, u međunarodnom humanitarnom pravu je razvijana sve konkretnija zabrana okrutnog postupanja.
So in the Geneva Convention from 1929, for example, you have general rules about how detainees should be treated, but they are of a general nature, so detainees should be treated humanely. Only after the Second World War, these rules are transformed into, let's say, the first attempts of international criminal law in the Nuremberg Charter. Cruel treatment is prohibited as a war crime and set out as a crime in the Nuremberg Charter. And there's also inhumane treatment as a crime against humanity. Notably, perhaps, is that torture is not included in the Nuremberg Charter. Torture is included soon afterwards in what we call the Control Council Law number 10, which is the legal instrument regulating most of the Second World War, post-Second World War trials, the major ones.
Really, it was the human rights framework which gave greater depth to what it meant to be free from torture. So it had an influence on that. With respect to human rights law, you had the Universal Declaration of Human Rights in 1948. There was a United Nations Declaration Against Torture, which followed quite some time later. The European Convention on Human Rights and the regional frameworks developed in the 50s and subsequently.
Following this, there is further development in international humanitarian law. So you have the Geneva Conventions from 1949, and you have the additional protocols from the 70s. They also set out rules about how detainees should be treated. Now a little bit more specific. You have rules again about detainees being treated humanely, But you also have specific rules about they should not be tortured, they should not be subject to cruel treatment and other provisions of that kind.
Ključni doprinos razvoju zaštite ljudskih prava dalo je usvajanje Konvencije Ujedinjenih nacija protiv mučenja i drugih okrutnih, neljudskih ili ponižavajućih postupaka ili kažnjavanja iz 1984. godine.
The Torture Convention from 1984 includes a very clear definition on what torture is, setting out the different elements, almost like you would have in a criminal law in a national, in a state. What is still missing, and that's perhaps where ICTY is another international criminal tribunal is coming in, is the enforcement aspect, how to ensure that the rules are followed.
The international instruments, the Geneva Conventions, are concerned with the behavior of states. We at the ICTY are concerned with the behavior of individuals.
Uprkos napretku u razvoju humanitarnog prava i zaštiti prava čovjeka, mučenje i okrutno postupanje su bili sve prisutni u zatočeničkim objektima i logorima tokom ratova na području bivše Jugoslavije. Već od prvih predmeta na Međunarodnom krivičnom sudu za bivšu Jugoslaviju čula su se svjedočenja žrtava tih zločina. U predmetu protiv Dragana Nikolića svjedoci su po prvi put govorili o nasilju kojem su bili izloženi za vrijeme zatočeništva.
Ten witnesses who were present at the relevant time in Vlasenica have with great courage decided to come to The Hague to testify in these proceedings. In full knowledge of their rights to witness protection, they have further elected to give their evidence openly in public. Theirs will be the first voices of victims to atrocities in the former Yugoslavia to testify before this International Criminal Tribunal, and by so doing, their voices will echo throughout the world.
Ibro Osmanovic was a man who testified in a number of trials at the ICTY. He's a native of Vlasenica in sort of the northeastern area of Bosnia, and Ibro told the chambers over the course of different trials how he came to be arrested one day for no particular reason and was taken to the police station in Vlasenica.
Zlostavljanje se izvodilo na sljedeći način. Otvaranjem vrata tog pritvora u kojem smo se mi nalazili, pokazivao je prstom na nas ti, nekad izvedu jednog, nekad dvojicu. Prostorija u kojoj je vršeno ispitivanje, nalazile su se 2 stolice i 1 sto. U tu prostoriju kada bi se ušlo, ruke bi se vezale za sto, prsa osobe bi bila naslonjena na naslon stolice, a noge bi bile vezane za stolicu, za prednje nogare od stolice, i obavezno bi bili skinuti do pasa.
And then what would happen?
Onda bi počinjelo tuča, tuku se raznim arsenalima, od obične policijske stanice, one palice, pa preko raznih motki, šipki, pa čak što više i lanaca.
During the time you were at you were in that location, the prison, can you estimate approximately how many times you were beaten?
Jedno 5 puta sam ja bio tučen.
Kako su suđenja odmicala, tribunalovi suci su čuli brojna svjedočenja o mučenju i okrutnom postupanju sa zatočenicima širom bivše Jugoslavije.
Sljedeće moje, kako da kažem, duel sa Alandžom je bio kada me negdje u sredinom 7. mjeseca došao do moga mjesta digao me i usput je rekao ovim ostalim zatvorenicima, sad ćete vidjeti šta će od njega da ostane. Ja sam mislio da će me da ubije, međutim doveo me pred izlaz, nismo izašli vaneve pred vrata u ćošak, naredio me da kleknem na koljena. Ja sam kleknuo, prosuo je benzin, vidio sam na bočica za upaljače, prosuo je, zapalio je, izvadio je neke one medicinske picete, počeo je da grije. Pitao me gdje je Mića. Ja u tom momentu nisam znao o kojem Mići je riječ. Tek kasnije sam kopčao o kojem Mići me pita, ja sam odgovarao da ne znam. Kada je dovoljno ugrijao te picete, počeo je da me prži. Naredio me da zinem, ja sam zinuo, da ispazim jezik. Ispazio se jezik, on je počeo da prži, doživljavao sam strahovite bolove, pržio je jezik, tako da mi je kasnije bio kao ta roštilja, usne po nosu, da bi u jednom momentu počeo i uho. Gurnuo je picetu, gurnuo je tako, ja sam osjetio strahovit bol, vrisnuo sam.
Torture is one of the most severe forms of cruel treatment and encompasses a wide range of acts across a broad spectrum, and and that spectrum can include acts like beating, psychological abuse, rape, and other forms of sexual violence, inhumane living conditions, forced transfer, deportation, unlawful detention. The spectrum is incredibly broad, and torture within that spectrum is recognized by the ICTY as one of the most severe attacks on human dignity.
It all very much depends on the circumstances, and a beating, let's say with your hands, can be serious enough under certain circumstances if the person is, let's say, detained or tied up, another vulnerable situation, and at the same time then you have beatings with tools, maybe the metal rods, what have you. That is serious enough simply because of the tools that are being used.
Unë dhe të tjerët kur në nxorën nga podrumi, pikëspari ata kërkuan që t'ju japim të holla, na kërkonin të holla, që na plaçkisnin. Pastaj filluan rrahjet e mëdha, të vazhdueshme, një mbas njëshme. Na urdhëruan që të shtrihemi për tokë dhe na rrahën. Ne morëm çka patëm aty me veti dhe nisi e rrahna me tek ne aty.
Can you briefly describe the treatment you and the others received?
Po. Filluan të na rrahen me çka kishin në dorë. Me armë, me shkelma, me çka kishin ata në dorët e tyre, filluan shumë keq na rrahen, jo vetëm u, por të gjithë aty që ishin.
What happened to Ismail Ramadani?
Ismail Ramadani gjatë torturave që ushtronin policia mbi neve, aty e preon me thik në shpinë, duke ja prerë me thik kriqin ja bon. Ja bon me thik kriqin.
When I returned from here, I went out to walk around your city.
Jedan za drugim, svjedoci su tribunalovim sudijama govorili o dugoročnim posljedicama nasilja koje su pretrpjeli u zatočeništvu.
There can be physical injuries that are visible. That has happened. There can be a missing finger or scars on a person that is clearly visible when the person is giving evidence. There might be other physical injuries that are not visible in the courtroom, so to speak, but that are described by the witness or the witness is bringing photographs, and that's presented as part of his testimony.
You described how you were black in your face and body. What sort of injuries did you suffer as a result of those beatings?
Ja sam imao povredu prije svega kičme od silnog udara. Zatim sam imao prelome zuba, 2 zuba, povrede po licu. Zatim po nogama imao sam otoke nogu. Cirkulacija je oslabila. Povrede lijeve strane bubrega, lijevog bubrega. Povrede po grudnom košu.
I want to ask separate about medical treatment, but do you have any results still from those injuries today?
Svakako da osjećam prije svega psihičke traume koje su prisutne još od tada i one se manifestiraju s vremena na vrijeme. Zatim osjećam povredu zglobova i stalne bolove u predelu kičme. Kada dišem, kad udahnem zrak u pluća i kad prestanem disati, onda osjećam da zrak ide iz pluća.
From a psychological point, individuals that we have worked with suffer from nightmares, from periods of rage. They have triggers which remind them of the incidents, and it's often something that remains with them for the rest of their lives. It can also be passed on to their children in the sense that the way the individual interacts with their family and those around them is affected by the treatment that they experienced.
A witness testified in the Karadzic case relating to, he gave evidence relating to his detention in a facility in Rogatica where he was beaten, where he was sexually assaulted, where he was tortured. And he spoke, and he was detained with his family, and he spoke and told us, the court, the chambers, the public, he told us about not only his the physical side effects or the physical effects of the torture, he told us about his greatest pain relating to that period, and that was that his 2 children who were detained with him were also sexually assaulted. If I'm not mistaken, the last time he gave evidence was more than 20 years after the incidents had happened, and the pain that he felt was a pain that he was brave enough to share with all of us, and that pain is something that kept him in treatment even to this day.
Then you have the mental injuries, which can be visible as well in a sense. You can see when people give testimony, when they talk about something that has happened to them and it's difficult, and they have problems in expressing what has happened to them, maybe avoiding certain details of the story, skipping it, or skating over it, or simply have difficulties. They do tell it, but they have difficulties expressing it. That's also, in a sense, a visible sign of the long-term effects.
The effects can resonate across the community, and by community I mean a couple of different things. So talking about a situation in a detention facility. For example, some of the women in Foča in the Partizan Sports Hall. woman, seeing women who are tortured will cause great fear in the other women. The effect may be that these women who are tortured will be shunned and stigmatized by their community. These women who have been tortured, shunned, stigmatized by their community may also have diseases, may also have disabilities, may not be able to bear children, may have any number of physical effects from the sexual assaults that they endured. These women who may be stigmatized and judged by their community may not have support from their families. These women may not be left with any other option as a result of what they went through than to leave. So the effects spread past the room in which the torture and cruel treatment might have happened, outside of confinement and over geography, over space and time, and can even change the demography.
Bez obzira na rasprostranjenost mučenja i okrutnog postupanja u logorima i zatočeničkim centrima na prostoru bivše Jugoslavije, dokazivanje tih krivičnih djela u sudnici nije bilo uvijek jednostavno.
Since a person who has been subject to these things rarely or never have access to medical service immediately after this have happened, you don't have that kind of documentation. You don't have medical documentation that is contemporaneous. You have medical documentation from much later, but not at the time. So that's, in a sense, is a weakness, and you are left with the testimony of the witness. Here you have two. Well, you have many, but you have certainly two weaknesses, let's say. One is the memory. How has the memory been affected over these many years, let's say 10, 20 years after the event?
U tome mi je nož, vojnički nož, podra tu, ovdje pro. Ovaj što me iza mene išao, udario me kundakom tu u desnu bubrege. Ovaj je trgao nož, ošno me po glavi, ovako pljoštr me sa tim nožom i onda onim čilinom ovdje udario i ovdje ja imam ožujak gdje me udario nožom.
And did you make an effort to see who those soldiers were?
Pa ja sam mislio da vidim, ali ja nisam mogao vidjeti čim ti mi je nož. Ja mislim, nema čovjeka koji bi mogao pogledati ako mu nož tu dojde pod vrat. Ja mislim da malo ljudi, nisam ni ja bio kakav, ja sam muškarac, ali nisam imao sile da se usudim da pogledam.
I should say, you're able to give details about what happened to you, the ill treatment, how it happened, and the whole situation. You might be less able to give details about things like time, when it happened, who did it to you. And that's an important aspect, of course, in a criminal trial. Who did this to you? You might not see who did it to you if you're not, if the beating is severe, if you're unconscious part of the time. And you might have no idea anyway, even if you had seen them, who these people are, and you might not notice things about them that could be important to identify them. Which accent did they speak? How were they dressed? What kind of insignia were on their clothes, and so on and so forth. And these, so that's, I would say, regardless of time, is of course a problem.
I think that we've come a long way to establishing some kind of historical record that will one day be used by younger generations in the countries of the former Yugoslavia to come to some kind of shared understanding, some kind of agreement, some kind of acceptance of the events that led to the conflict and the conflict.
Uprkos preprekama, tribunal je uspješno osudio više od 40 počinilaca krivičnih dijela mučenja i okrutnog postupanja.
These are determinations made in context based on a detailed analysis of the totality of the evidence. And you look at different things, and trial chambers have looked at different things. You can look, for example, at the length of time over which the treatment might have taken place. You can look at the institutionalization of the treatment. You can look at the specific acts themselves. You can look at the scope of the treatment. And sometimes you can find that evidence in what the perpetrators themselves might have said. In the Nikolić case, the accused admitted the torture.
Časni sude, ja sam potpuno svjestan svega onoga zašto se teretim. Svjestan sam dijela koja sam počinio. To sam i priznao tačku po tačku koja mi je ovdje pročitana. Izjasnio sam se da sam kriv. Preuzimam svu odgovornost za ta dijela koja sam počinio. Kako se osjećam povodom toga što sam činio u tom periodu za ta 3 mjeseca koja sam proveo u Sušici, to jedino ja znam, ali ono je bitno da stvarno osjećam veliku dozu sramote i stida.
Dugogodišnja sudska praksa tribunala pomogla je u uspostavljanju savremenog shvatanja krivičnih dijela mučenja i okrutnog postupanja.
It's always been recognized and is very clear in the UN Convention Against Torture that for an act to amount to torture, it must have been carried out for a specific purpose, which is prohibited.
The purpose can be to gain certain information or a confession from the person you are inflicting this pain on. It can be to intimidate him. It can be to punish him. It can also be for any other reason that is done on discriminatory grounds.
What the ICTY recognized was that with respect to the fact patterns that were put before it, sometimes the purpose can be implied from the context. So it's not always necessary to have to prove it affirmatively that the purpose is present. The ICTY also recognized in its jurisprudence that actually purpose was not the most central aspect of the definition. The severity of the harm is a far more important component within the context of crimes against humanity, war crimes, or genocide. Prohibited purpose, part of it, but certainly not the most essential elements.
When it comes to rape, this is one of the acts that ICTY judges have said passes the severity test, is an act that in and of its own is severe enough to cause torture.
Rape, because of how it's defined, by how it's understood, will all by necessity involve severe pain and suffering.
La Chambre d'appel souhaite préciser que certains actes établissent per se la souffrance de ceux qui les subissent. Le viol est évidemment l'un de ceux-ci. De plus, la motivation sexuelle admise par les accusés n'exclut certainement pas ni leur intention de commettre un acte qui a eu pour conséquence de causer de grandes souffrances, ni la poursuite d'un but discriminatoire.
Osim toga, sudije Tribunala su modifikovale postojeću definiciju mučenja i prilagodile je kontekstu međunarodnog krivičnog prava.
The definition under the United Nations Convention Against Torture specifies two clear things amongst the range of aspects of its definition, one of which is that torture has to have the involvement of a public official. So in the context of human rights law, that makes perfect sense, because human rights law is the contract between the state and the citizens, the individuals in the state who benefit from the human rights protections.
Another aspect is an understanding, or I would say a modification perhaps of the definition of torture as it exists in international human rights law. One of the trial chambers, the Kunarat's trial chamber, looked at the definition in the Torture Convention. So looking at all that and digging into the work that led up to the Torture Convention and also to the commentaries on the Geneva Conventions, they clarified that as part of the definition of torture in international criminal law, there was no requirement that torture had to be committed by a public official or with the consent of a public official.
The ICTY jurisprudence recognized that when torture is considered as an element of a crime against humanity or war crime, etc., that the involvement of the state is not a prerequisite. It's not required. Torture is a practice which can be meted out by any person in authority, particularly parties to a conflict. That was a really important development for the law, and it's had transversal effects in human rights law.
It was tempting for the first trial chambers to simply take the definition of torture that as it existed, but not critically thinking about does it make sense to take this one from another field of law and put it into international criminal law. And I think that's where the Kunarat's trial chamber made an important contribution.
Tribunal je također postao prvi međunarodni krivični sud koji je mučenje proglasio zločinom koji nikada ne može biti opravdan.
Of course, from international criminal law framework, the ICTY and to an extent the ICTR as well, we're the first tribunals to really interpret what torture meant in a modern context, in the context of crimes against humanity, war crimes, or even genocide.
Because of the work of the ICTY in this area, the definition of torture has a place in international criminal law.
The Farungia decision of the ICTY is probably the most known decision for human rights advocates. And the reason for that is because very clear in that decision, extremely clear in that decision, you have a statement that torture, the prohibition of torture, is a form of jus cogens, that it is absolutely prohibited in all circumstances, and there are no exceptions to that.
In Section 6, the trial chamber commences a discussion of the elements of each of the offenses charged in the amended indictment. This section contains a comprehensive analysis of the nature and status of the prohibition against torture under conventional and customary international law, as well as providing a definition of torture under international humanitarian law. In this regard, the trial chamber finds that the prohibition against torture has attained the status of jus cogens.
Simple principle. But that principle has not been stated as clearly as that in any previous decision. So the role of the Frunzia decision, and it's been cited in domestic courts, human rights courts around the world, has been so important, particularly taking into account the use of torture evidence, the resort to treatment which would amount to torture in the context of the war on terror.
There are no exceptions to the prohibition against torture. If there is nothing to be found in the ICTY case law that such exception should exist. If anything, the ICTY case law has confirmed, to the extent it needed to be confirmed, that the prohibition against torture is absolute without any possibility of derogation.
Uprkos tome što je Konvencija Ujedinjenih nacija protiv mučenja gotovo univerzalno usvojena i uprkos vrlo jasnoj sudskoj praksi Tribunala i drugih međunarodnih sudova, mučenje i dalje primjenjuju i državni i paravojni akteri širom svijeta.
International criminal law is not perfect. It's not perfect because underpinning it is state will to comply. State will to comply varies. It varies along a time continuum. Sometimes states are feeling more compliance than at other times. It also has to do with power and how power is divided amongst states.
I think in general, the fact that torture does happen, that it still happens all over the world, it's not really a reason to say the rule is not there. There is no prohibition, and it's not an absolute prohibition. The rule is there. I think from international law point of view, that's very clear. There's no question about it.
I think we absolutely are making progress. What we're not doing is making progress which is in a straight line. And there's a typical reaction to greater human rights protections and greater rule of law is a backslide. The backslide may be political, it may be legal. It simply says, well, maybe we're moving too fast for where the consensus is. That is the role of lawyers, it's the role of human rights activists, it's the role of victims to keep up the fight and to keep pushing, and we do. If we take a long-term view, we have made so much progress. We've made tremendous amount of progress. The fact that there is jurisprudence in a variety of countries, even countries that might surprise us, this is a sign of progress. That we have backslide, I think, is a natural aspect of the fight, which is hard and long and complex.
When it comes to torture and cruel treatment, the fact-finding of the ICTY judgments has been, I think, immensely important in starting to chip away at the culture of denial of crimes that is actually starting to grow again in the regions of the former Yugoslavia. So I think that that's been an immensely important part of the legacy of the ICTY.
Kontinuirani napori istražitelja i tužilaca Tribunala igrali su ključnu ulogu u utvrđivanju činjenica o krivičnim djelima mučenja i okrutnog postupanja tokom sukoba u bivšoj Jugoslaviji. Sudska praksa Tribunala će biti korištena u borbi protiv mučenja i okrutnog postupanja širom svijeta dugo nakon što Međunarodni sud zatvori svoja vrata 2017. godine.
I think ICTY's role in international criminal law is unparalleled. I think the role ICTY has played for the development of this whole legal framework, ICC statute certainly, but also the role of other tribunals and the position of other tribunals ICTY really plays an enormously important role in that respect.
The impact is already being felt with respect to the definition of torture and its relationship to non-state actors. I think that that is the most critical area where the ICTY jurisprudence has had an impact. It's had an impact in how states in different countries have chosen to implement their obligation to have domestic laws that prohibit torture. So, for instance, recently Uganda adopted a law prohibiting torture. Because of the particular context in Uganda, and this was a live issue, which was debated quite extensively, but the Ugandan government decided to include non-state actors amongst those who could be prosecuted for the crime of torture, which is really important in that context.
But the thing is, and I was trying to explain this to some 16-year-olds yesterday, because somebody said to me, what difference did you make? International justice takes so long. And I said, the difference we made is because we made the law in areas where there was none. And without the law, you have nothing to work towards. You have no accountability. You have no consequences. You have no reason to fight for anything better. With the law behind you, you have strength.